Okay. Barrister, let's move to the next topic. If we are done with this. On the next topic, we shall be talking about the Labour Party. We shall be talking about the Labour Party. I don't know if you followed what happened, their meeting. They had a meeting 2 days ago in Abia State with the governor, a Labour Party governor, OT. And they came out, Obi spoke, and the governor himself spoke, and some things, they decided on some things, and Abure has been kind of ousted out. Before before we go into that detail, let me play this video. I want you to, it's in line with this as well. This video was I think Kenneth Okonkwo was the one who, in fact, he personally forwarded it, because I don't watch Arise TV anymore. I stopped watching Arise TV because there are a bunch of, especially that Rufai and Ruben, there are a bunch of liberals that their comments pisses me off. So I just thought, so he forwarded, Kenneth Okonkwo actually forwarded. I've invited him on this show to actually speak on, I don't know, he's been evading my invitation. So he forwarded it to me, and he said something on that sounded interesting. Now, I don't know if you have read, did you read the message, the letter, a public letter Kenneth Okonkwo wrote about Peter Obi? Did you go through that?
I saw the headline, but
Yeah, actually, I think I had a monologue on that, because when I read that, that man mirrored everything. And that was the reason why after that letter, I called him. We spoke at length. I told him, if I wanted us to discuss it on this show. Unfortunately, I don't know. He said he has said too much about that topic, that he wouldn't want to go into that. But even at that, even on phone, off record, we even, for over 1 hour plus, we talked about that or whatever. This man he just actually spoke my mind. I have my own this thing against him during what he did, his actions, political decisions during what's his name, Buhari's regime or whatever. We even talked about that briefly or whatever. So he gave his reason why he did that and all that stuff or whatever. But honestly, he just spoke my mind. And again, on this video again, he spoke my mind. And that's why I want you, but there are some legal things I want you as a lawyer to actually, because he quoted some things about the election and the electoral process and the INEC and with the last presidential election judgment and other stuff. So I want you to take a look and listen to him. It's about 3 minutes video. I carved it out, I made it smaller for just this point. So you listen, take a look at it, watch it, and then let's get your input if you agree with him or not. Can you hear that? Can you hear him clearly?
No, I can't hear the voice.
What about now?
The voice is yet to come out.
Oh, really?
Mm.
Okay.
I'm seeing the picture, but the voice is not there.
Okay, hold on. Let's see. All right. Sorry, since I don't know, there is some kind of hitch here. So viewers, I'm sorry you cannot. Unfortunately, you can't see the video. So, but let me just use because I don't have time to troubleshoot this. Let me use my phone for Barrister. So the only thing he will hear is just the sound. Okay, what I will do? Hold on. Let's do it this way. Can you see it now, right, Barrister?
Yeah, I can see the pictures.
Okay, what I'll do is, let me do this. Put it this way. Then.
Trying to take power from a Tinubu will be a tall dream. And the reason is this. Our electoral system and judicial system have been overthrown. As long as the electoral process is concerned, Here are my reasons. I was a member of the presidential team, and I can tell you unequivocally that our electoral jurisprudence has been destroyed. And the courts did this by giving INEC discretion to do whatever they like. The court say INEC has discretion on whether to transmit electronically or not. This is not what the law says. Let me make it clear, in my own opinion. So power does not proceed any longer from the will of the people in Nigeria, but from the discretion of INEC and from the desecration of the judiciary. And having that as bottom line, the opposition, they are just wasting their time. What Lamido said is true, because a Tinubu outside government was able to overwhelm the system. What about a Tinubu inside government? Now, let me tell you why I say our electoral jurisprudence has been overthrown. The court said, if you do not bring your petition, if you do not bring all your witness statement on oath, if you don't bring all your evidence within 21 days, your case is dead. Respectfully, again, that's not what the law says. The law says in section 285, subsection 5, petition should be presented within 21 days. According to Rule 4, subsection 1D, petition simply means the facts that you need to prove, the grounds and the relief sought. It is not the evidence. In Rule 5, the rule for procedure for election said evidence need not be stated in the petition, but the court may give order that you should provide further particulars to prevent surprise and avoid unnecessary expense and to ensure fair and proper hearing of the suit. Meaning, the court, by subpoena, can allow subpoena witnesses to give evidence after 21 days, because that's the only way that you will avoid unnecessary expense to the petitioner and ensure fair hearing. Why? An adverse witness will never voluntarily give you evidence that you will use against it. INEC, whenever they pronounce anybody as winner, when they come to court, they are under obligation to defend their own action. So they can never willingly give you evidence. The only choice you have is that when the court starts sitting, you will now use subpoenaed power to bring them to give evidence. Now the court is saying, once the court has started, if you've not produced any witness statement oath, your petition is dead. That means whatever INEC does, that is final. Then again, they move further. And the secret section what?
All right, Barrister, you had everything right?
Yes, I heard everything.
Okay, beautiful. So what's your take on that? Do you agree with him?
We
As a lawyer?
have discussed this very issue on this platform a couple of times.
Okay, yeah.
And I totally agree with him. I even go further to say that with the state of the law as espoused by the Supreme Court, it is a total waste of time and resources to go to court. And 2027 is going to be a physical snatching of the election, and nothing will happen, because the way the electoral jurisprudence has been structured, which I have said is almost criminal, there's no way that a petitioner will succeed in the court on a practical level. As a lawyer of so many decades, I've done a lot of election petitions. I know what goes into it. I know the sheer difficulty of gathering your materials to enable you present a petition. And in the case of a presidential election that involves the whole country, hundreds of thousands of polling units, it is practically impossible to present a credible petition within the confines of the law as the Supreme Court has determined. I also mentioned in one of our discussions that, look, this thing was deliberate. It's not as if the law was cast in iron in the way that the Supreme Court delivered its ruling. There was leeway for the Supreme Court to do it the other way. It was a 50-50 case. They could rule the other way, but they chose to go the other way. And that has compromised our democracy. That has compromised our electoral jurisprudence, rendered it useless, so to speak. Because the issue, apart from the issue of time, which is very limited from a practical legal point, 21 days to submit a petition, a presidential election petition that involved 36 states, hundreds and thousands of 774 local governments, hundreds of thousands of polling units. And when you complain about conduct of a presiding officer, you must bring evidence of that particular police station. How is that feasible to do that in the election petition? I have been involved in the politics, both in the, at one time I was a member, I served in what is today INEC as a returning officer, as a presiding officer. I've also served as a party official. So I have a very clear understanding of the difficulty when the elections are conducted. Most of the times the evidence comes much after. Even when you are hearing the petition in court, you begin to see critical evidence at that point, because the process of collecting the evidence is onerous and it's not subject to you, because the people who operate the system, the INEC, do not willingly cooperate with the parties. The military, the police that also participate do not willingly cooperate with the petitioner. You have to force them by virtue of what we call a subpoena, a court order. So how are you to do that within the 21 days, when in most cases the tribunal has not even started sitting? When do you get an order or subpoena to serve on INEC, to serve on police, to serve on the army, to serve on presiding officers, and take their statement, what we call witness statement, and attach it to your petition within the before you submit it within 21 days? It's not practically possible. I heard Kenneth Okonkwo quoting the Electoral Act, but he did not also quote a provision that requires what we call front loading. The Act expects you to do what we call front loading, which means that you put all your evidence, all your witness deposition, the evidence each of your witnesses is coming to give, put it in writing, attach it to the petition before you file. That is the real difficulty. And because you cannot get that evidence from police, from INEC, from the military and public officials who were involved in the election, you have to go to the tribunal to give you an order. Can you do that within 21 days? In most cases, the tribunal has not even started sitting within the 21 days. So they have made it impossible for any credible petition to be presented and succeed. That is my gross with the Supreme Court. They could have, within the Electoral Act, there was leeway that they could have done so. And I told you on this platform before that if there is any jurisprudence that should be devoid of technicality, should be 100% devoid of technicality, it should be electoral jurisprudence, because it's the most important litigation in the country, because it deals with the people who are coming to rule us, to take decisions that affect our lives, affect our economic life. So how can such determination be subject to 100% technicality? It's absurd. It's even criminal. There should be no single technicality involved in election cases. At any point before judgment, if evidence comes to show that the person did not genuinely win or is not qualified to contest, the tribunal or court should be able to hear it because of the importance of the type of case we are hearing, the court is hearing. But the reverse is the case in Nigeria. They have put layers upon layers upon layers of technicality, some of them totally absurd. So it has made the whole thing virtually useless. To that extent, I agree with him that the electoral jurisprudence has been bastardized, has been criminally undermined. Coming to 2027, the point, you have made the point before, and he made it, and I agree wholeheartedly. If this man was disabled and was able to capture the power, to take it and run with it, now that he's able, who will now near him?
That is the point.
When he did not have control of the army, control of the army, control of all this public official coercive machinery, he was able to snatch it and run with it. Now that he has all these instruments at his disposal, who will even come near him?
That's the point.
All these people now talking about merger, talking about 2027, they will. I just pity them. I do not see anything.
Yeah, that will bring. We'll talk about that in the next while we are talking about the